Namaste, Suswagatam, and welcome to another episode of Nyay Gyan Ganga, Legal Words of Wisdom, hosted by the Virat Hindustan Sangam social media channels every Saturday. And today is a Saturday and it's 8 p.m. Indian Standard Time. We are back with Dr. Subramanian Swamy and Dr. Venkat Iyer, who's a barrister based in Ireland. He's a Bombay origin lawyer who migrated to the United Kingdoms and since then has been teaching there, practicing there. He's a barrister and he moves around the entire globe teaching media personnel, students, and various government authorities, including judges and lawyers, on various aspects and evolving laws across the globe. So, as you know, he has been very kind to lecture uh, Indian common person on the Indian law, and today he is back on the second episode. And we thank Dr. Venkat Iyer for again coming and telling our audience the importance of law and various other aspects. As you know, last week he spoke to us a brief introduction, how our law is based on the British system, importance of parliament, etc. So with this, without wasting much time, I'll just give you a brief idea of what our today's episode is all about. Today is an introduction to the different types of law and legal terminology. What are the key difference between civil and criminal law, public and private law, and domestic and international law? And why are those differences important? Why do legal terms, what do legal terms such as suit, prosecution, plaintiff, defendant, petitioner, respondent, damages, affidavit in camera, jurisdiction, sub judice mean? How are the courts in India organized? Because many of you may be wondering what is the difference between the various courts. Can parties conduct litigation on their own or do they need lawyers? A classic example is Dr. Swamy not being a law degree holder. How does he practice in court? These are some of the issues that will be dealt with in this lecture. So with this, I would now request Dr. Subramanian Swamy to start the introductory remarks and then Dr. Venkat Iyer will take over and explain all these issues today. I must thank my colleague, Mr. Ramesh Swamy, and our technical team of Ashish Shetty, uh, Tejas, Rakesh, Swaminathan, and our friend from Navi Mumbai, uh, Ishwar Iyer, and Vishal Mehta for their background support, and our Virat Hindustan Sangam office bearers and leaders for their inputs for undertaking this Saturday program. Our Sunday program at 8 p.m. will also continue. So we have two programs, one on Saturday on the legal issue at 8 p.m. and every Sunday also a regular program at 8 p.m. Thank you. With this, I would request Dr. Swamy to start our program today.
Well, thank you very much, Jagdish and Ramesh, and of course, the trouble that Venkat is taking for us. I know that his opportunity cost of coming here is very heavy. You could have used this 1 hour or half an hour, whatever he takes, for great use in his legal activities, but he has sacrificed it for VHS. We are thankful to you for that. And basically, the idea is that, as I said yesterday and elaborated in a different angle today, we want people to be able to challenge other people, no matter how powerful, how rich, by knowing the nuances of law and knowing exactly which law to use and under what articles of the Constitution we can get an enforcement of what we want done in fair play. So the more you empower the citizen in a country in terms of the law, without requiring fancy lawyers with high command as the rich people have. You are actually empowered to strengthen democracy, and you will see that once you are able to do that, how people are, no matter how powerful they are, how much cautious they are in dealing with you. I have learned law because it was easy for me. First of all, my wife was a lawyer, so she had all the books. And two, I learned law because it's basically an exercise in logic. So if you are clear in your mind, and of course, if you're in an academic field, you have to be clear in your logic when you present research papers. So with that background, you can go and argue yourself, and so that you are completely freed from the heavy financial costs of having to engage in litigation. I also would like to tell you that Section 32 of the Advocates Act um, permits people without law degrees to argue in court, provided the judge is satisfied that you are capable of knowing the legal formalities and the jargon and the attitudes that you have to have for being a lawyer. And I had established this by a series of public interest litigation. Public interest litigation don't need permission of the court, because public interest, you are representing yourself. You are part of the public. So you also say, I am part of the public, but the exact same problem is there for all citizens of the country. And therefore, I'm representing the citizens also of the country. So public interest litigation, must know the legal formalities, the jargon, and so on. Otherwise, you'll be laughed out of court. So I've seen many public interest litigation by citizens because they can't afford a lawyer, and then they're all shooed out of court. But in my case, no one is willing to believe that I don't have a law degree. But that's because I have having been a professor of economics, I'm also all vary in it, but all told, you must know your rights, you must know the limits of your rights, and you must know how to enforce your rights. That is citizenship, or rather the ball game that is called law. And we can't find anybody better to do that than Venkat. And so, Dr. Venkat Iyer, over.
In my last lecture, I provided an overview of the Indian legal system. Before I get into the issues that I plan to discuss today, I want to say that I've been overwhelmed by the response I've received to last week's lecture. The feedback that's come my way has been very positive, and in addition, Jagdish sent me some viewing figures which were heartening. There was also a very helpful suggestion from Swamy, one of many, which I intend to take up, namely that we might in future episodes include questions from the audience. These are to be filtered by Swamy, which will give the programs an element of interactivity. In the meantime, of course, please do keep your feedback coming via the chat box. I realize that you may find the first 2 or 3 lectures a bit dry because I'm dealing with some general issues about the Indian legal system. But I want to assure you that there is a purpose behind my focus on these issues. It is to lay the ground for what is to follow, especially for the benefit of viewers outside India, and the VHS I know has quite a few of them who may not be as familiar with the basics of Indian law as others might be. I want to start today's talk with a look at how law is classified. This is not, believe me, intended to be an academic exercise, but a purely practical one, because classification determines to a large extent how you use the law, especially when you have to resort to court procedures. I'll start with something basic, the difference between civil and criminal law. This is a distinction which is important because the Indian legal system has separate courts and procedures for each of these branches of law. Perhaps the easiest way of differentiating civil law from criminal law is to talk about objectives. Generally speaking, the objective of civil law is to provide someone who is aggrieved, that is to say, who has suffered harm, loss, or injury, compensation for his grievance. Typically, therefore, a civil suit will result in a sum of money being awarded to the person bringing the suit. But sometimes the person bringing the case may ask for other remedies, such as an injunction or a stay order or restitution of property. Typical cases of civil law would include a suit for the recovery of a debt, a fight over disputed property, or a claim for compensation for personal injury. By contrast, the objective of criminal law is to punish a wrongdoer. Criminal cases are therefore brought in the name of the state, although it is possible in limited circumstances for cases to be launched by private individuals. Punishment as such is justified on a number of grounds, including to prevent reoffending, to serve as a vindication to the victim of crime, to name and shame the offender, to serve as a deterrent to others, and so on. Now, one of the important differences between civil and criminal law is the burden of proof. That is what the bringing the case needs to do to be successful. I'm talking actually about the standard of proof. For criminal cases, they have the people bringing the case have to prove their assertions beyond reasonable doubt. So, for example, if you want someone punished for, say, stealing your bag, you'll have to prove to the satisfaction of the court that the person whom you're accusing of the offense is responsible beyond reasonable doubt. By contrast, if you're bringing a civil case, you only have to prove your assertions on a balance of probabilities, which means you have to show to the satisfaction of the court that it is more likely than not that the person you're bringing the case against is responsible for the wrongful act. Now, this is an important distinction because generally speaking, the burden of proof in criminal cases is higher than the burden of proof in civil cases, which is why it's more difficult to succeed in criminal cases than it is to succeed in civil cases. This then raises the question, is it possible for the same set of circumstances or the same incident to give rise to both a civil and a criminal case? And the answer is an emphatic yes. Perhaps the easiest way in which I can illustrate this is by referring you to the well-known incident involving the American footballer O.J. Simpson, who was, as you know, implicated in the murder of his ex-wife and another person in 1994. You'll recall that when Simpson was charged with the murders, the criminal case failed in 1995. But when the families of the deceased brought civil cases, they succeeded, and Simpson was ordered to pay some, I think it was $33.5 million by way of compensation in 1997. Aside, you'll note that the process of justice in countries like the US is quite swift. Both those cases were disposed of within 3 years of the incident. I don't have to tell you that any prospect of getting such quick results in India would be a forlorn hope. It's worth noting a few things about terminology, especially in India, where even experienced media people often use sloppy language. A civil case is called a suit. The person bringing the civil case is called the plaintiff, and the person against whom the case is brought is called the defendant, or sometimes the respondent, for example, in matrimonial cases. So if you hear someone say A is suing B, then what is being referred to is a civil case. By contrast, a criminal case is called a prosecution, which means that you prosecute someone whom you want punished. Criminal cases are, as I said earlier, usually brought in the name of the state, and therefore the side which launches the case is called the prosecution. The person against whom a criminal case is brought is either the accused or the defendant. Staying with terminology, there's one other important set of words which we need to keep in mind, and it has to do with compensation, which, as I said earlier, is usually awarded in civil cases. The technical word for compensation is damages, and you need to recognize that damages is not the plural of damage, as it is frequently assumed in India. An easy way of remembering this point is to note that damage leads to damages, so that when, let's say, your car suffers damage as a result of someone else's negligent driving, you can seek damages from that person. You should also keep in mind the difference between damages and fines. Both involve money, but when you pay a fine, it goes to the state and not to the person at whose instance the criminal case may have been brought. Damages, on the other hand, go to the plaintiff in a civil case. As a general rule, damages can only be awarded in civil cases, but exceptionally, it may be possible for compensation to be ordered in favor of the victim of a crime in a criminal case also. This then brings me to another important practical point. Civil and criminal cases are heard in different courts, which means that if you want to take both civil and criminal legal action in relation to the same incident, you will have to launch proceedings separately and not assume that you can combine them. How then are the Indian courts organized? The first thing to note is that there is both a vertical and a horizontal dimension to the organization of the courts. The horizontal dimension involves a split between, first of all, the metropolitan and the non-metropolitan, that is district level courts, and then also between the civil and criminal courts. And the vertical dimension involves a hierarchy of courts in both of those branches. To make all this easier to understand, I'm asking Ramesh to put up sort of a graphical representation of the court structure on the screen. If I were to explain the structure in detail, it will not only take a disproportionate amount of time, but it's likely to bore you stiff. For that reason, I'll stick to a simplified summary. You can, of course, go back to the chart at your leisure because these lectures are going to be stored on various social media platforms. So first, taking the criminal courts, which you'll see in the chart clearly identified, the lowest rung of the ladder, as it were, consists of the magistrates' courts. These are courts where most criminal cases begin their life. There are different types of magistrates with different sentencing powers, but generally speaking, the maximum punishment that can be awarded in a magistrate's court is, if my memory serves me right, imprisonment for up to 7 years with or without a fine. Next up comes the Sessions Court, which deals with more serious cases and which has unlimited punishing powers, including the power to impose death sentences. Above the Sessions Court comes the High Court, which entertains appeals from the Sessions and Magistrates Courts. Also, of course, every sentence of death has to be confirmed by the High Court before it can take effect. Very exceptionally, a High Court may even conduct a criminal trial itself after transferring the case from a lower court. And at the very top of the hierarchy is a Supreme Court, to which only appeals can be taken in criminal cases. Now, moving to the other side, the civil side, the lowest rung is either the Munsif's Court, which is the lowest court in the districts, or the small causes courts in cities. At the next higher level is the district or city civil courts, although there are a few other courts in between, especially in the districts, such as the Court of the Civil Judge Junior Division. Then comes the High Court, which can entertain both first-time cases and appeals from the lower courts. Every state in India has a High Court, although in some cases the High Court is physically shared between two or more states. So an example would be the High Court of Punjab and Haryana, which exercises jurisdiction not only over those two states, but also over the Union Territory of Chandigarh. Occasionally, a High Court may have benches in cities which are not its principal seat. And the example I can give is of the Bombay High Court, which has benches in Nagpur, Aurangabad, and Goa. Finally, there's a Supreme Court, to which certain appeals can be taken in civil cases, but only with leave or permission. There's much more to be said about the power of the High Courts and the Supreme Court, but I may have to leave a lot of that to another lecture for lack of time. I'll also have to leave a discussion of tribunals, lok adalats, etc. for a later occasion. But I want to deal with one issue which has relevance to the classification of law, and that is the distinction between private and public law. This distinction again has significant practical implications, and so I'd like to spend a few minutes explaining it. Generally speaking, when there's a dispute between two or more private parties, that is, take a dispute over property or succession or custody of children or employment, then that dispute will fall within what is called private law. And such disputes will usually be dealt with by a civil court as a suit. But if there is a dispute involving an organ or an agency of the state, for example, a challenge to an order passed by the Commissioner of Police banning a procession, or a challenge to the allocation of public resources in an arbitrary manner, then such a dispute will fall within the ambit of public law, and it will be dealt with under a separate type of proceeding called judicial review. In India, such proceedings are called writ petitions. One needs to be very careful in choosing the correct procedure for launching cases. In India, tactics play an important part in these decisions because, generally speaking, writ petitions are heard and disposed of much faster than ordinary suits. And so people try to dress up as many cases as possible under the public law garb. But it's important to realize that writ petitions cannot be filed against purely private entities, for example, a corporation, however strong your grievance against such an entity might be. Lawyers do, of course, have some tricks up their sleeve in trying to overcome this major hurdle. And one of them is to direct their petition against the government and ask the court to order the government to do something which they want the private party to do. I've seen too many cases of this kind being taken to the courts over the years, and this, coupled with the alacrity with which many judges are willing to enter the arena of policy making, sometimes with good intentions, I have to add, has led to a worrying situation. The problem has been compounded by a rampant misuse of that peculiarly Indian invention and phenomenon, public interest litigation, to which Swamy made reference earlier, with the result that sooner or later, I fear that there is bound to be a complete breakdown of the system, which is already creaking, and a fierce backlash against the distortion of the public-private law divide. And that in turn will, again, I fear, shake the confidence of the people in the administration of justice even more. I'm incidentally going to talk at length about public interest litigation in a later lecture, but I want to say at this stage that I'm not unsympathetic to the aims of PIL, just worried about the consequences of how PIL is being used, or should I say misused. Perhaps this may be an opportune moment for me to tell you about a few other pieces of terminology that you should know so that you get a fuller picture of how the courts work. You may have heard about affidavits. What are they? They are essentially sworn statements that parties or others sometimes need to submit to a court. It is extremely important that everything said in an affidavit is true to the knowledge of the person making the affidavit, who incidentally is called the deponent. If an untruth is discovered, the deponent can be punished severely for an offense called perjury. Another term that you'll come across a lot in relation to a court is jurisdiction. What it means is the source and the limits of the power to make legal decisions. Therefore, if a court does not have jurisdiction to deal with a case, it means that it cannot legally deal with that case. Jurisdiction can be of different types. You can have territorial jurisdiction, which means power over a geographic area for the purposes of entertaining litigation, or pecuniary jurisdiction, which means power based on the monetary value of the claim being made in a case, or you can have subject matter jurisdiction, which means power based on the subject matter of the dispute, for example, succession or tax or employment or immigration. Sometimes you'll be told that a case is being heard in camera. What this means is that there is a closed hearing to which anyone other than the parties, their lawyers, witnesses, etc., will not be allowed to attend. And this happens when sensitive matters need to be discussed, such as those concerning national security or trade secrets or offenses relating to children. Unless a court clearly indicates that a case is being heard in camera, anyone who wishes to remain present in court can do so, subject, of course, to availability of space in the courtroom. It is a general principle of the rule of law, to which I made reference in my last lecture, that the administration of justice will be open and transparent. Again, the implications of this are quite profound, and I hope to be able to discuss it in another lecture. One other term which comes up frequently is sub judice. This means that certain aspects, especially the merits of a pending case, shall not be discussed in public. I'm afraid there's a lot of misunderstanding and ignorance about the sub judice rule in India, and I
Yeah.
shall therefore discuss this matter also at greater length later on. Um, you will also come across the phrase ex parte hearing sometimes. What that means is a proceeding which is granted at the request of and is intended for the benefit of one party only, at which the other party or parties would not be represented. Um, Now, it's necessary, I think, also to understand how the legal profession in India is organized. The first thing to note is that everybody has a right to conduct legal proceedings in person if they choose to do so. And what better example can offer of this than our dear friend Swamy, whose record as a litigant in person is second to none. In practice, however, most people engage lawyers, mainly because the law can often be intimidating and complex to most people who are not well versed in it. In formal terms, a lawyer in India is called an advocate, but certain other terms are also used in practice. For example, a solicitor, who is a lawyer who prepares the documentation, who deals with court officials, and who offers basic legal advice. Or you may come across the term counsel, spelled C-O-U-N-S-E-L, not C-I-L, who is a lawyer who represents a client in court and who has more specialist knowledge than a solicitor. Now, appearing in a court is what is called a reserved legal activity, and it can only be undertaken by anyone with formal legal qualifications. Although, as Swamy pointed out at the beginning of this talk, there is a section in the Advocates Act, Section 32, which allows a court in India to permit anyone not enrolled as an advocate to appear in any proceedings before it. The crucial thing about that section is that you need permission of the court. Now, what happens when a lawyer misbehaves or acts negligently or fraudulently? The answer is that he can be hauled up before the profession's regulator, the Bar Council, although many people believe that there are serious shortcomings in that process. I shall discuss this issue in a later lecture because I think it's of very practical value to the common man. To complete the classification of law, I need to refer to the distinction between domestic law and international law, especially because I often come across muddled thinking on this point. Very simply, domestic law is a body of law that applies within the territorial limits of a country, and international law is a body of law which applies across national boundaries. Incidentally, there are two types of international law, private international law and public international law. But since I'm coming very close to the end of my time, I'll have to defer a discussion of the differences between those two types to a later occasion. Generally speaking, international law is, at least in terms of its enforcement potential, much weaker than domestic law. And this is particularly true of public international law, which is often enmeshed in geopolitics. One thing that's worth noting is that any piece of international law, if it has to have any legal effect in India, has to be absorbed or translated into domestic law first by the Indian Parliament. It cannot be applied directly. That is why when India signed up to certain commitments, for example, under the World Trade Organization regime, it had to amend many of its laws to ensure that they are harmonious with those commitments. I realize that I've had in the course of this lecture to compress a lot, and also that I could not deal at requisite length with some of the other issues that I wanted to talk about, or even the ones that I outlined. Rest assured, however, that I shall dilate upon those as we go along. And I do, of course, value your feedback. So if there are any particular issues on which you want me to speak more elaborately, feel free to let me know via the comments box. I'm afraid I have to stop for the present, but I look forward to reconnecting with you next week. Thank you.
Dr. Venkat, there is a question from our viewer. A viewer wants to know that can a criminal case be initiated by a private individual? As you mentioned earlier, the complainant or the prosecutor is the state. So our viewer would like to know that can a criminal case be filed by a private individual in the court, and what is the status of such a thing? So this is what a viewer wants to know.
Thank you. The short answer is yes. Now, the way it works is that there are two ways in which uh, criminal prosecutions can be launched. The first is what is typically used in a majority of circumstances, majority of cases, and that is by a person lodging a first information report with the police. And then the police investigates the alleged offense and decides whether to prosecute or not. The second route, which is what I think your viewer has in mind, is a situation where you don't go to the police, but you go straight to the magistrate. In other words, a complainant goes, technically, you would call that person a complainant. So he would go and lodge a complaint with a magistrate. And the magistrate then takes it upon himself or herself to look into the complaint, and if it is deemed fit to be prosecuted, then the proceedings begin from that point onwards. So the short answer really is yes, you can take up, you can initiate a prosecution on that basis. And if my memory serves me right, the procedure for that is to be is contained in section 200 of the Criminal Procedure Code.
Thank you, Dr. Venkat, for that. So with this, we come to an end of another episode of the Legal Words of Wisdom, Nyaya Ganga, which we air every Saturday at 8 p.m. Indian Standard Time on our Virat Hindustan Sangam social media channels. As you all know, we are available twice a week for the legal one every Saturday at 8 p.m. and for our normal Gyan Ganga Words of Wisdom every Sunday at 8 p.m. with Dr. Subramanian Swamy on different topics. So we see you now tomorrow Sunday at 8 p.m. for our normal program, and we'll see you next week and every week Saturday at 8 p.m. Thank you, Dhanyavad, and Jai Hind.
Thank you.